free of influences which made it untrustworthy or probably untrue. Thus, Wigmore, the leading authority on evidence, reflected the law prevailing at the 1940s of any connection with the privilege against self-incrimination. The court did not apply the privilege against compulsory self-incrimination to the proceedings in the police station and other in-custody questioning until its 1966 decision in Miranda. The untrustworthiness rationale and view that the rules governing the admissibility of confessions were merely a system of safeguards against false confessions could explain the exclusion of the confession in Brown v. Mississippi, 1936, and the first 14th Amendment due process confession case conceded that one had been whipped, but not too much for a Negro, and the same rationale was also adequate to explain the exclusion of confessions in the cases that immediately followed the Brown case, such as Chambers v. Florida, 1940, and Ward v. Texas, 1942. The extended police questioning to which Ashcroft had been subjected inherently coercive, the court considered to be dangerous and subject to abuse. Although he joined Justice Jackson's dissent in Ashcroft, Justice Frankfurter soon became the leading exponent of the police misconduct. The confessions, according to this rationale, for offensive or otherwise objectionable police interrogation methods, it was necessary to exclude confessions produced by such methods regardless of how trustworthy they may be. Thus, in Watts v. Indiana, 1949, and two companion cases, the court reversed 3 convictions resting on coerced confessions and were not shaken as to truth by anything that occurred at the trial. Justice Frankfurter, who wrote the principal opinion in Watts' procedure, which violates the basic notion of our accusatorial mode of prosecuting crime, and case of Roshan v. California, discussed page 37. Justice Frankfurter viewed the coerced confession cases as only instances of the general requirement that states in their prosecution respect certain decencies of civilized conduct. Involuntary confessions, he pointed out, are inadmissible under the Due Process Clause, even though statements contained in them may be independently established as true. They offend the community's sense of fair play and decency. Perhaps the most emphatic statement of the police methods rationale appears in Rogers v. Richmond, 1961, one of the Justice Frankfurter's last opinions on after accusing another who in turn